Did a federal judge just say that publicly available emails prove Dr. Fauci was communicating and acting as an intermediary for others in order to censor information from being shared across multiple social media outlets? The court has no doubt that Dr. Fauci was engaged in communications with high-ranking social media officials. Any burden imposed on Dr. Fauci for his deposition, and I'm going to walk you through that deposition order, is wholly outweighed by the importance of the plaintiff's allegation of suppression of free speech. What am I talking about? I'm talking about a big case out of the U.S. District Court in Louisiana, where 2 state attorney generals are, along with 5 individuals, are suing no less than 68 government officials across 14 federal agencies, including the President of the United States, the White House Press Secretary, the Surgeon General, the CDC, the Department of Justice, the FBI, the Department of Homeland Security, Health and Human Services, the Census Bureau, the Department of Commerce, and it goes on. Why? Because the plaintiffs, these state attorney generals and individual plaintiffs, allege that the government colluded with and/or coerced social media companies to suppress free speech in violation of the United States First Amendment by labeling that free speech, labeling the content as disinformation, misinformation, and malinformation. And those 3 terms should send chills down your spine if you know anything about history. When they start using terms like disinformation and malinformation, I kid you not. The court has granted expedited discovery, these expedited depositions of these 10 government officials, and I'm going to walk you through that court order. And we're going to take a look at, in particular, these exact words that the judge has said in his order and why that's important. Did these government officials censor information? And why does that matter? It matters because the government is not allowed to censor free speech, not allowed to suppress free speech according to the First Amendment of the U.S. Constitution. So hi there, I'm Michelle Hagan. I'm a legal analyst and a former prosecutor. I am providing this video. We're going to walk through the court's order. This video is for education and information purposes. I want to thank all of you who have subscribed to my channel. To welcome all of those new subscribers, please hit that like button, share these videos, and please do leave a comment or question. Because this video is simply my opinion, it's my analysis, and I want to know what your analysis is. Do you think these government officials, including Dr. Fauci, Jen Psaki, the Surgeon General, do you think they violated the First Amendment of the Constitution, suppressing free speech? So let's take a look at what the judge said. It's a case out of Louisiana. It's a federal district court case. Okay, so it is in the federal system. So let me show you. I'm going to walk you through the court's order here. It was filed October 21st, so a couple days ago. It's a 28-page opinion. This is an order where the judge is requiring these 10 government officials to submit to depositions. Why? Because the judge needs to determine whether or not to grant the plaintiff's request for a preliminary injunction, meaning to stop government officials, to stop these 14 agencies from censoring, suppressing free speech as alleged by the plaintiffs, okay? So the judge is trying to gather information. These depositions will help gather more information as to whether or not the judge will grant a preliminary injunction, in other words, to stop these government agencies from censoring information, from suppressing free speech as alleged by the plaintiffs. And the plaintiffs are also requesting that it be a permanent injunction, okay, so that they can't do this in the future. All right, so let's take a look at what the judge said. And again, words matter, and it's important. Important to read what the judge said here and who's involved. So it's United States District Court. So that's at the federal level, okay? Why is it at the federal level? Because we're dealing with a constitutional question. Did these government officials violate the Constitution, the First Amendment, by suppressing free speech, by engaged in, as the plaintiffs call it, a censorship enterprise between social media companies and all of these federal agencies, okay? The other reason is because the states' attorney generals have filed it in federal court, okay? So, and it's involving federal agencies and a constitutional question. So the federal court is where the case is taking place. So it's the state of Missouri versus Joe Biden et al., and that's those 68 plaintiffs. I'm sorry, 68 defendants. You know, the press secretary, White House press secretary, the Surgeon General, the Secretary of the Department of Health and Human Services, the Department of Health and Human Services, Dr. Anthony Fauci as the director of the National Institute of Allergy and Infectious Diseases, and chief medical advisor to the president, the NIAID, the CDC, the chief of the digital media branch for the CDC, and it goes on. Officials from the Census Bureau, from the Department of Commerce, from the Department of Homeland Security, from the CISA, the Cyber Security and Infrastructure Security Agency, the White House National Climate Advisor, the more people from the White House. Let's see, several more people from the White House. Everybody from the senior advisor, the digital strategy advisor, etc. Many. U.S. Department of Justice, the FBI, agents from the FBI, several officials from the CDC, officials from the HSS, the FDA, the Office of Management and Budget, the Department of Treasury, the U.S. Election Commission, etc. I mean, there's 68 defendants, 68 government officials are the named defendants in this lawsuit filed by the 2 state attorney generals and the 5 individuals against these government officials and these government agencies, alleging that they coerced or colluded with social media companies to suppress free speech. It's very serious. Very serious if they can prove this. So let's see why the judge is allowing these plaintiffs, the state attorney generals and these individual plaintiffs' attorneys, to depose these government officials. And who are they? So it's an expedited preliminary injunction. That means it's expedited because they're asking for the judge to intervene and to stop these government officials from censoring information and these government agencies from censoring information. So they're asking for the court to grant these depositions, all right? So the plaintiffs allege that the defendants have colluded with and or coerced social media companies to suppress disfavored speakers, viewpoints, and content on social media platforms by labeling the content, as I said earlier, disinformation, misinformation, and malinformation. And you can look at the footnotes here to see who the defendants are and who the plaintiffs are. So looking at footnote 1, it's the plaintiffs consist of the state of Missouri, the state of Louisiana, right, by their attorney generals, a couple doctors. One's from Stanford, a doctor from Harvard, an epidemiologist. Another one is a doctor from UC Irvine. And then we have another individual, Jim Hoft, who has a website called Gateway Pundit. He's also one of the plaintiffs, and Jill Hines is also one of the plaintiffs. She started Reopen Louisiana, and she also is involved with the Louisiana Consumer and Human Rights Advocacy Agency. So those are the plaintiffs. You can take a look at it. And the defendants, as I named off, that's 68 defendants across 14 government agencies, including the White House. So the plaintiffs here are alleging that the plaintiff's freedom of speech was violated by a violation of the First Amendment of the United States Constitution. They also set forth examples of suppression of free speech. The Hunter Biden laptop, which was suppressed prior to the 2020 presidential election, is what they're alleging here, is examples of suppression of free speech. They're alleging that speech around the lab leak theory was also suppressed. Speech around efficacy of masks and lockdowns also suppressed. Speech around election integrity, security of voting by mail was also suppressed, as they allege, and censorship and suppression of speech by these several plaintiffs, these individual plaintiffs. You can go ahead and take a look at that. So the court is doing a limited focus here, limited inquiry on whether or not the court should grant a preliminary injunction to stop these agencies from engaging in a censoring activity or suppressing free speech. That's the question. So the judge is granting these depositions to allow the plaintiffs to ask questions of these government officials to find out what happened, who did what, and what happened. The defendants opposed the deposition of these individuals, and you can take a look at that. So here's the law. Expedited discovery is rarely granted, basically. It's not the norm. Courts only allow it in limited circumstances, and it's a heavy burden, a high burden, that the plaintiffs have to meet. And they met it because the judge is granting their request to depose these individuals. So it has to be compelling testimony of high-ranking government officials is justified only in extraordinary instances. And in this case, this judge found that it's an extraordinary instance because if censorship in violation of the First Amendment, suppression of free speech is going on, the court can issue an injunction and stop it from occurring or continuing to occur. So the courts usually don't grant expedited discovery involving high-ranking government officials because of separation of powers. They don't want to have disruption of the executive branch. They don't want the government officials to be vulnerable to numerous repetitive, harassing, and abusive depositions. The general rule is to prohibit depositions of high-ranking government officials. So why did this judge grant it? Well, because these officials had firsthand knowledge, according to the plaintiffs, and that information is unobtainable from other sources. So the defendants, all the government agencies objected, all the plaintiffs objected. The defendants objected, and again, they're all being sued in their official capacity. They're not being sued as individuals. Now, some other attorney out there can determine whether or not they could be personally sued, for instance, acting outside the scope of their employment or their role, violating the Constitution. Maybe that's an argument some attorney down the line or possibly is already making. I don't know. So anyway, and the court does not intend to prohibit depositions of newly added defendants. Now, in this case, in the state of Missouri versus Joe Biden case, they have already added new defendants. So they went from, in the first complaint, because this is the second, they did an amended complaint, they added about 40 some odd government officials. So the plaintiffs could bring a request for depositions of these other 68 government officials. We'll have to see. So plaintiff's argument here, why did they want to depose Dr. Fauci? Well, Fauci is a named defendant in the case. He's also the chief medical advisor and the director of NIAID. And the plaintiffs allege that Dr. Fauci was directly involved in the censorship campaign, and that the plaintiffs argued that the speech backed by great scientific credibility was, which contradicted Dr. Fauci's views, was censored on social media at the insistence of Dr. Fauci. You can go ahead and read this. They also talk about Dr. Fauci's efforts to discredit the lab leak theory, and that they assert that Dr. Fauci, who I think it's pretty much known here, funded the research at the Institute of Virology, and that there was a potential implication if it was the lab leak theory that maybe Dr. Fauci and this other Dr. Daszak would be responsible or the cause of funding research. That's an interesting question. And they also talk about a conference call with scientists who may or may not have been discrediting the lab leak theory. But after the call, the plaintiffs allege influential individuals, these scientists, signed public statements that were placed in science journals in an attempt to discredit the lab leak theory. Do you see here? There looks to be some campaign of censorship, suppressing information out there, as alleged by the plaintiffs. They also talk about Dr. Fauci engaging in written and oral communications with Mark Zuckerberg, who's I think the CEO of Facebook or Meta, talking about the government's response and allegedly widespread social media campaign to censor. So again, these are all allegations, right? Allegations doesn't mean it's true. But what is going on here is my question. Plaintiffs further allege that publicly available, and this is the statement I started this video with, publicly available emails between Dr. Fauci and Collins regarding this effort to discredit the lab leak theory and also to censor the theory online, and that there were emails that scientists expressed their concerns that there looked like there was bioengineering going on. And then these same scientists authored a paper that was published in the Nature Medicine journal that discredited the lab leak theory. So here they're asking questions, and then they do an about face, and now they write an article that discredits the lab leak theory. That paper was also sent to Dr. Fauci for approval. Plaintiffs allege that Dr. Fauci and Mark Zuckerberg engaged in a course of friendly and oral communications regarding the government's response. And then in April, Dr. Collins emailed Dr. Fauci about Brett Baer's article about the lab leak theory. And Dr. Collins, I guess, was expressing his concerns over whether NIH could help take down the very destructive conspiracy. He further stated that they hoped that the Nature Medicine article would settle this and asked what more we could do about it. Dr. Collins requested Dr. Fauci to use more public pressure to stop the theory from circulating. Is this evidence of government officials engaging in censoring information, suppressing free speech? Plaintiffs also talk about the Great Barrington Declaration. That's the declaration where several doctors, including a couple of these plaintiffs, Stanford doctor, the Harvard doctor, got together with several other doctors. I think they had over 90,000 signatures from other doctors across the world because they were questioning whether or not the prolonged lockdowns was an appropriate response. Well, here it is. Here's an email. Dr. Collins' email. Dr. Collins is head of the National Institute of Health. Hi, Tony and Cliff. This proposal from talking about the Great Barrington Declaration. This proposal from the 3 fringe epidemiologists and even a co-signature from a Nobel Prize winner Mike Levitt at Stanford. There needs to be a quick and devastating published takedown I don't see anything like that online yet. Is it underway, Francis? Here's an email where a government official, Fauci, it looks like Dr. Collins, and Tony, I assume that's Tony Fauci, where Dr. Collins is asking them about a quick and devastating takedown of these epidemiologists from Stanford, from Harvard, and a Nobel Prize winner because they're questioning the lockdown? And Dr. Fauci making public statements that were highly critical, describing it as a total nonsense and ridiculous, this great bearing. Total nonsense and ridiculous for doctors to express their opinion, their speech about whether or not, questioning whether or not the lockdowns was appropriate. The plaintiffs also assert that Fauci was involved in Twitter's permanent suspension of a critic by the name of Alex Berenson. And Alex Berenson is important because when he sued Twitter because they suspended his Twitter account, when he sued Twitter, there was information, emails, evidence that came out in that lawsuit that is very helpful in this lawsuit, where the attorney generals are suing these government officials, right? So White House officials, including Andrew Slavitt, specifically pressured, according allegations here, pressured Twitter to deplatform Berenson. Dr. Fauci publicly described Berenson's opinion on vaccines as horrifying. President Biden followed Dr. Fauci's steps and made a statement: they're killing people by not censoring misinformation. The President of the United States is asking for social media. Is that what that says? On October 13, 2020, Berenson posted on Substack. He posted these Twitter emails indicating that a board member of Pfizer pressured Twitter to deplatform Berenson. Okay, all the social media companies can do their own censorship, okay? But the problem is when the government is telling you, you become an agent of the government. These social media platforms are acting on behalf of the government, which is a roundabout way of the government actually suppressing free speech. That's the problem. You can go ahead and read these. I thought it was really interesting here. Let's see. So the plaintiffs sent interrogatories. Those are written questions to Dr. Fauci, asking him about, what he knows about. Was he engaged in censoring? Did he have communications with anybody at Facebook, at Google, at LinkedIn, at Twitter, etc.? What does Dr. Fauci do? He refuses to verify under oath his own interrogatory responses in violation of the court's order. Instead, what do? They have Dr. Jill Harper verify his responses. Really? You can go ahead and read this. And the plaintiffs argue that Dr. Fauci's credibility has been in question on matters related to misinformation. He made public statements about the efficacy of masks. First, he said they weren't helpful. Then he changed his position. The percentage of population needed for herd immunity, those percentages varied. The NIAID's funding of the research, the lab leak theory, etc. Why are they suppressing free speech? Why are they, if it's proven to be true, why are they doing this? Why are government officials suppressing free speech? Have they not read the Constitution? If this is proven, okay? Again, it's an allegation. Doesn't mean it's true. And here's what the court says as to why they granted the plaintiff's request for a deposition of Anthony Fauci. It's exactly what I said. Publicly available emails that prove that Dr. Fauci was communicating and acting as an intermediary for others in order to censor information from being shared across multiple social media outlets. There's emails out there that prove, according to this judge, that Fauci engaged in censorship. The second reason the judge granted in compelling the deposition of Anthony Fauci. Fauci has yet to give any statements under oath as to what happened, right? He didn't verify his interrogatories. He had someone else do it against violating a court order. He's supposed to verify his interrogatories, his answers to those questions. The third reason the court said the court has no doubt that Fauci was engaged in communications. Why was he talking to social media officials? Why? Any burden that may be imposed on Dr. Fauci is wholly outweighed by the importance of the plaintiff's allegation of suppression of free speech. Did Fauci and these other defendants violate and suppress free speech? Who else is being compelled to submit to a deposition? Rob Flaherty, White House Director of Digital Strategy. He's a key official in the White House, according to this. According to this order here, he had extensive oral meetings with social media platforms, including Twitter, Meta, and YouTube. Plaintiffs also allege that Flaherty, the White House Director of Digital Strategy, consistently communicated with Meta's director through COVID insight reports, which detail trends and posts by social media users. Why does the government want to know? Why are they doing these reports to find out what was being posted by social media users? You can go ahead and read this. Pressuring Meta by sending them an article about misinformation on Facebook with the subject line, "Not sure what to say anymore." In other words, is the White House saying that the Meta official didn't understand what the direction was from the White House? Is that what that's saying here? I don't know. What do you think? I mean, I'm just beside myself reading this. Have these people not read the Constitution? Plaintiffs maintain that deposing Flaherty is essential because of critical information on the White House's pressure campaign to social media platforms against the disinformation dozen over misinformation issues. They actually called 12 social media users the disinformation dozen. Isn't that in and of itself talking about they had identified people that they were going to censor by giving them a name? The disinformation dozen. Okay, again, this is just my opinion and my free speech. And the White House involvement over content modulation. Content? That means they're censoring what's being posted based on content, whether or not they like the content or don't like the content. Policies instilled in Meta and Twitter in an effort to remove harmful misinformation. There's a reason the First Amendment. There's a reason free speech is in the First Amendment. Because, as Jefferson or Ben Franklin said, if you don't have free speech, you don't have anything. If governments are allowed to censor information, to regulate what speech, or to intimidate you to self-censor, where does that lead? And why? Why? And who determines what's misinformation? Who determines that? Government officials? Why is it the Founding Fathers put that in the Declaration, put it in the U.S. Constitution, the First Amendment? Why are they protecting free speech? Why are they guaranteeing free speech? Congress shall not. What does it say here? Let me get out my little booklet here. I should know this by heart, but shall not. I have to look it up. Where is it? I just had it. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. That's the First Amendment of the U.S. Constitution. Congress, government officials are included. The government is not allowed to suppress free speech. You have the right to say whatever you want. Whether or not someone sues you for defamation, that's a whole nother story. But who determines what's misinformation? The government? These officials? People that may be implicated in funding a lab that may have created a deadly disease, deadly or harmful disease? And look at footnote 24. Supposedly, there are a dozen accounts across social media that the government officials have taken to calling these accounts disinformation dozen. The government's identified people that they're going to target and suppress their free speech. Is that what that's saying? Andrew Slavitt, the White House senior advisor to the White House, allegedly led the charge for the White House and its campaign with social media companies to increase censorship of private speech. Defendants' own discovery, the discovery that they provided to the plaintiffs, reveals that Slavitt received Facebook bi-weekly content reports. In other words, they were providing to the White House what was being posted across these social media platforms for the White House, I guess, to oversee Facebook censorship. Is that what that says? Look at this. On April 21st, White House staff will be briefed by Twitter on misinformation. Twitter to cover trends seen around misinformation. What interventions are currently being implemented? Isn't this proof that's showing that the government is colluding or coercing social media platforms to censor free speech? Is that what I'm reading? On March 2nd, Meta sent an email assuring government officials Slavitt, Flaherty, and Humphrey that the company is combating misinformation and de-amplifying content. What does that mean, de-amplifying? Particularly focusing on entities that repeatedly post misinformation, mitigating viral content. So doesn't this email tell us that social media platforms are working with the government to suppress content? To de-amplify content? Plaintiffs also cite to a podcast that Slavitt participated in where he said he was pushing organizations like Facebook from spewing misinformation, pushing the company to be more responsible. Isn't that another example of the government pressuring or coercing social media? Slavitt, because of his role as a, quote, self-professed principal enforcer of online censorship by the government? The court doesn't see any burden imposed on Slavitt that outweighs the court's need for the information in order to make a most informative decision on whether or not to grant this preliminary injunction, to stop the government officials and the government agencies from engaging in this conduct. His communications, actions, and orders to and between social media platforms will be necessary. This is the judge saying it. Will be necessary for the court to make its ruling. Jen Psaki, the former White House press secretary, her deposition is also going to be taken. Why? Because of public statements that she allegedly made, public threats of adverse legal consequences to social media platforms if they do not increase censorship of views disfavored Views disfavored. I can't even speak. Disfavored by federal officials. March 5th, on May 5th, Psaki stated at a White House press conference, the major platforms have a responsibility to stop amplifying untrustworthy content, disinformation, misinformation. There are those words again. What is disinformation? What's information? And who determines it? There's a reason there's free speech. Because if we start saying, we don't like your speech, we don't like your speech, so we're not going to do it. We're going to cancel you. We're not going to let you have a Twitter account. We're going to de-amplify your social media account. Psaki stated in another press conference July 15th she was in regular touch with the social media platforms. They're supposed to be separate. The government can run its own campaign, but when they use a private company to censor, allegedly, to censor speech that they don't like, they can't do that. That's suppression of free speech. And here's Psaki talking about the disinformation dozen. Even she uses that term. So she's aware that 12 people were identified, social media users, to be given, in their opinion, posting misinformation or speech that should be suppressed or censored, according to this statement here. All 12 of them remain active on Facebook. Facebook needs to move more quickly to remove harmful posts. Did she actually say that? Oh. Also called on social media platforms for their consistency in banning disfavored speakers. Disfavored speakers. Demanded robust strategies from social media campaigns. She maintained regular contact with social media platforms. Why? You can do private censorship, but when the government gets involved, the Constitution gets involved. You can't be violating free speech. If this is proven, oh boy. Defendants' response to the interrogatories, because Psaki has left the White House, there's a new press secretary. They responded with the interrogatories saying they lacked the basis of knowledge as to what went on. But they did say that Rob Flaherty and Andrew Slavitt were involved in the communication with social media platforms. The court said Psaki has made a number of statements that are relevant to the government's involvement in a number of social media platforms. Elvis Chan, an FBI agent, and this is interesting what the judge said about this FBI agent. This FBI agent was involved in coordinating with social media platforms relating to censorship and suppression. Has anyone read the Constitution? In support of this argument, plaintiff cites a podcast where Mark Zuckerberg stated that communications from FBI led to Facebook censoring stories on Hunter Biden's laptop. Meta Counsel, Facebook's counsel, identified Chan as the FBI agent who communicated with Facebook to suppress that story. Is this true? An FBI agent went to Facebook and told him to suppress any stories regarding Hunter Biden? Is that what happened? Oh my gosh. And here's what the judge said. And this is interesting. As stated above, Chan was identified as the FBI agent who communicated with Facebook to suppress a story about Hunter Biden's laptop. When did this occur? Just prior to the election. If he did this, the judge says, the court ultimately finds there are reasons to believe that he has interfered in other ways. Wow. Jen Easterly, CISA director. What is that? It's apparently a department, an agency within a Department of Homeland Security, where, according to the plaintiff, she supervises the nerve center of federally directed censorship. Has anyone read the Constitution? They allege that CISA's central role directly flagging misinformation to the campaign. So in other words, this CISA agency flags misinformation, tells social media companies what? To take it down, to suppress it? This part just is chilling. Plaintiff also asserts that Easterly's claim that social media speech by Americans is a form of infrastructure and that policing speech online by the federal government falls within her agency's mission to protect infrastructure, stating that the most critical infrastructure is cognitive infrastructure. What does that mean? Our thoughts, our ideas, our infrastructure that needs to be censored by her agency? Is that what this is saying? Plaintiffs also cite Easterly's text messages regarding the Disinformation Governance Board. What the heck? How Easterly seeks greater censorship that would be done by federal pressure on social media platforms to increase censorship. Has she read the First Amendment? Does she know what free speech is? Is this true? In the interrogatories, the response to the interrogatories, CISA discloses extensive oral communications in meetings between CISA and social media platforms. So they're admitting they met with social media platforms. What did you talk about? Why were you meeting? But they didn't identify who these officials were. And Easterly would have that information, so she's being deposed. And the court said that you can depose either one of them because apparently, I guess what the judge is saying, whatever information they give would help the judge make a determination whether or not to grant the plaintiff's request to stop the censorship. Number 7, CISA mis, dis, and malinformation team. That exists? Really? Oh my gosh. CISA mis, dis, and malinformation team, the MDM team. That means mobile device management. Mobile device management team, whose mission is allegedly a federally induced censorship of social media speech. What? There's a federal agency out there that's mission is to induce censorship of social media speech? Protentis is apparently a leader and expert to create a line of control over the censorship of social media. Is this admitting that they are controlling social media? That the social media is an agent of is that what that's saying? Also argued that her contacts with the company were so persuasive that senior officials in other departments asked her to introduce them to the social media. What is going on here? There's a vital connection between CISA and social media platforms in the government censorship. And look at this statement here. So there's social media platforms in the government censorship efforts, has special knowledge in election security space, and look at this, provides briefings to governments of foreign countries on how to interact with social media companies. What? We have a federal agency that's teaching foreign countries how to what? Censor social media platforms? They assert that Protenda's testimony will establish context of the meetings, extent of CISA's election security efforts, tools the government uses on social media platforms. What does that mean? And efforts to influence election officials and encourage them to use social media companies to censor voters? This is a bombshell. I'm just appalled. If this is true, there's agencies out there that are doing this. There's government officials. These emails, what is going on? And why are they doing this? Vivek Murthy, the Surgeon General. Surgeon General requested a request for information on March 2nd, requesting tech platforms to provide him with information about misinformation, including the identities of those supposedly spreading it on their sites. So the Surgeon General of the United States is asking private social media companies to provide him with a list of individuals that are engaged in misinformation. Murthy's other statements, as well as those of President Joe Biden and Jen Psaki, this RFA was an intimidation tactic designed to frighten the tech companies into compliance in fear of reprisal. That's what the plaintiffs are saying. Plaintiffs urge that Dr. Murthy's texts and emails through discovery be provided, and that Murthy also engaged in communications that was even sent reports. Murthy was sent reports from the social media companies to obtain his opinion on whether or not to censor. Isn't that showing that a government official is working with a social media company to censor? Social media companies censoring what the government official tells them to do? Direct and routine contact with senior Meta executives. His action, this is what the judge says. His actions went beyond the scope of his rank. And the court finds that those actions must be addressed through a deposition. What is the Surgeon General doing? Getting the names of social media users, talking to social media companies around censorship. What is going on here? Dr. Murthy made public statements about how the media company's failure to censor is related to users' deaths. Did he really make statements like that? Carol Crawford, CDC, is also, she's chief of the digital media branch. Her deposition is going to be taken. She allegedly participated in emails with employees of Twitter, Meta, and Google, and YouTube. She organized the BOLO meetings, Be on the Lookout, to quell the spread of misinformation in 2021. She flagged certain social media posts, allegedly, and urged the participants not to share the information exchanged in the meetings, so to keep it secret that they were doing this. She also worked with the Census Bureau. Why the Census Bureau? In an effort to identify certain social media users who were spreading misinformation. These are all allegations again, I'll remind you. Plaintiff claims that Crawford's communications showed that the CDC, the Census Bureau, and other government agencies collaborated with Facebook to censor speech. And they claim she was involved in the censorship enterprise from the beginning. And her role with the Census Bureau, they allege, would shed light on that agency, the Census Bureau's agency's role in flagging misinformation the previous year. Number 10. Daniel Kimmage, State Department's Global Engagement Center Coordinator. I didn't even know about this. The State Department has a Global Engagement Center, and what do? Allegedly works closely with Easterly and the CISA to coordinate social media censorship of speech on election-related issues and election integrity. Really? That's what they do? Plaintiffs allege that in response to the third-party subpoenas, Twitter identified Kimmage as communicating with Twitter about censorship and content modulation. So now we have the State Department allegedly involved in this? to combat disinformation. Again, who determines what's misinformation and disinformation, and why are they doing this? They claim that GEC collaborated with CISA in the 2020 and the 2022 to create and fund an alliance of third-party nonprofits called the Election Integrity Partnership, which pushed for social media censorship. So they have nonprofits also acting on behalf of the government. Is that what this is saying? To suppress free speech? They also produced documents by LinkedIn. LinkedIn produced documents about face-to-face meetings that they had with State Department officials. And they said, the judge said here, this role as the acting coordinator for global engagement for the State Department, this role is vastly important to the issues at hand, according to the judge. And here are the people, again, to restate. So, and here's the judge. I wanted to show this to you. For some reason, it's kicking me back here. I got a gremlin. This order was signed October 21st by Terry Doughty. I hope I'm saying that right. The U.S. District Judge. A federal judge is ordering that these government officials submit to deposition to find out what's going on. Did they coerce or collude with social media companies to censor free speech in violation of the First Amendment? Wow. So when I have a moment, I'll walk you through the actual complaint, the lawsuit, and what they're alleging, the violation of the First Amendment by these government officials. And again, they're all sued in their official capacity. Nobody is sued personally as of yet, and maybe that'll happen, maybe it won't. And again, a lawsuit is just an allegation. It doesn't mean any of this is true. But what I have just read to you, that order that is issued by this judge, federal judge, where they cite specific emails, press conferences, tweets between government officials and social media platform, censoring free speech. Did that occur? And if so, the judge is probably going to grant this injunction, this preliminary injunction. That means to stop it now. And then whether the judge issues a permanent injunction, which is what the plaintiff is also seeking, and they're not seeking any monetary damages. They're just asking the court to find these people in violation of the First Amendment, to find that they have exceeded their authority, they have violated an administrative act, and that they are permanently enjoined from engaging in this activity. Keep it separate. Government's not supposed to be suppressing if the First Amendment has any value, right? Government is not allowed to suppress free speech, even if they disagree with the opinions. You and I can do it. We can tell people, you can suppress private speech, but when the government gets involved, and why is that? Why did the founding fathers? Why is the First Amendment? Why does it exist? Why are people allowed to engage in free speech in the United States? Because they value ideas, the opinions, and then the richness of sharing ideas to figure out what the truth is. But if you keep it one-sided, you prohibit people from seeing any what you call disfavored views or misinformation, then it's only one side, right? You're only going to be told what the government tells you and be exposed to information that the government allows you to see. Is that what's going on here? Censorship. Wow. Okay, so I went a bit long there. So thank you very much for listening. This is an important issue, and this is a fascinating case. Fascinating case legally. So please do leave a comment or question or whatever your opinion is. I want to hear it. What's your analysis? So thank you very much for watching. Please hit that like button. Please subscribe to this channel. Thanks again for watching.